I am prepared to tell you that I would, at this point, sign an arrest warrant for one or more persons for the crime of murder.
The single heaviest thing anyone has said about this case did not come from a comment section. Not a viral theory, not an anonymous post from someone who wasn't even there. It came from a man who used to sign arrest warrants for a living. A former Mississippi judge. Someone who sat on the bench, who signed these exact documents in real courtrooms, weighing real evidence, telling you that if the file landed on his desk today, he would authorize an arrest for murder. Now, I want to be careful with that from the very first second, because the care is the whole point. That is a legal opinion from a man who is no longer on the bench. It is not a charge, it is not a finding. This is still an active investigation, but when a person with that specific background says that specific thing, on the record, with his name attached to it, it deserves to be understood precisely. Not inflated, not dismissed. So tonight, let's walk through what actually pushed him there. The independent autopsy that answered less than it raised. The evidence the state kept back. And the pieces that, taken one at a time, mean nothing, but that a judge says stack into something. If you're new here, this channel does one thing. It separates what's confirmed from what's just loud. Subscribe so you don't miss the moment this case actually moves. First, who is even saying this? Because the weight of the claim depends entirely on the weight of the person making it.
Good evening, friends. I'm attorney Carlos Moore coming to you live from Atlanta, Georgia this evening. I'm currently a practicing attorney in Tennessee. I'm a former Mississippi judge. I sat on the bench in Mississippi for 6.5 years. In not one, but two jurisdictions. I was on the municipal bench in Clarksdale, Mississippi from 2017 to 2024. And I was on the municipal bench in Grenada, Mississippi from 2020 to 2024. So I had several years of experience. I had the authority to sign search warrants, arrest warrants. I had the authority to preside over arraignments, initial appearances, and preliminary hearings for trial for individuals accused of various offenses up to and including murder. So come on in, share this with your friends and family, and we are ready to talk about the autopsy and where we go from here.
Years on the bench across 2 Mississippi jurisdictions, the authority to sign search warrants, to sign arrest warrants, to preside over the early stages of cases as serious as murder. This is not a commentator guessing from the outside. This is a man describing a threshold he has personally applied, over and over, to decide whether the state gets to take away a person's freedom. Hold on to that, because everything he says next runs straight through it. Here's what he was waiting on before he'd say any of it. The autopsy. The family didn't trust the state's process, so they went and got their own, arranged through attorney Ben Crump, performed by Dr. Roger Mitchell in Washington. And Mitchell is not a minor name, former chief medical examiner of the nation's capital, a pathologist with a national reputation behind him. And here's the result that reframes this whole case.
All right, so the family commissioned an autopsy, an independent autopsy, because they did not trust the local officials. And they decided to hire attorney Ben Crump and ask him to have an independent autopsy done. So he commissioned Dr. Roger Mitchell out of Washington, D.C. Dr. Mitchell is a well-respected forensic pathologist. He has been the chief medical examiner for Washington, D.C. He's been the president of the National Medical Association. And he's also been over the hospital at Howard University. So he's very well respected. I've known Dr. Mitchell for over 14 years. He's actually done some forensic pathology work for me, independent autopsies, and some of the cases I handle when I was practicing in Mississippi and other places. So he's very well respected. He did the independent autopsy for me after Antoine Shumpert was killed under suspicious circumstances in Tupelo in 2015. So I'm very appreciative of the thorough work that he does. So here are the results First and foremost, the results were inconclusive. He could not tell the cause of death. Dr. Mitchell could not rule out definitively foul play or external factors. So right at the very beginning, he could not rule out foul play after conducting a forensic exam of Nolan Wells. And that's different from Sheriff Ledbetter of Jackson County, who within 1 day of Mr. Wells being found dead stated that no foul play was suspected. So he had done no exam, was not qualified to do an exam, and immediately came to that conclusion. So that's why everyone has been up in alarm since that time, and the family, rightfully so, got an independent autopsy. And Dr. Mitchell has stated that he still is not unable to rule out. He's still unable to rule out foul play. It could have been foul play. He could not give us a definitive cause of death at this time. He did notice a red discoloration in the soft tissue at the back of Wells' head. However, he stated that it remained unclear whether it was caused by blunt force trauma or simply natural decomposition. So it's possible that it was a result of blunt force trauma, but he could not state that to a reasonable degree of medical certainty at this time. He was able to say that there were no wounds or fractures. He didn't find any deep tissue injuries, lacerations, or bone fractures on the body. He did say that the body was severely decomposed due to the alleged time that Wells spent in the water. He could not accurately assess the skin surface for any signs of bruising or abrasions.
Inconclusive. He could not give a cause of death. And this is the part that matters most. He could not rule out foul play. Sit in the gap there for a second, because within roughly 24 hours of Nolan's body being recovered, the Jackson County Sheriff had already stated that no foul play was suspected. 1 day. And now a nationally respected forensic pathologist, with the body in front of him, is saying the honest answer is, we cannot say that. Both of those statements cannot be equally careful. One of them was made too fast. And that timing is the whole reason this case never settled. A cause of death is not a first impression. It is not something you read off a body at the water's edge. It is a conclusion you earn after toxicology, after tissue analysis, after the slow forensic work that takes weeks. When the most authoritative version of no foul play arrives inside a single day, before that work could possibly be finished, it doesn't close the question. It opens a bigger one, which is, how did anyone know that fast? Moore's answer is that they couldn't have. And a family that senses an answer was reached before the evidence was in is a family that will never stop asking for a second look. That's exactly what they did. Mitchell did note a single physical finding, a red discoloration in the tissue at the back of Nolan's head. But he was cautious about it, and I'm going to be just as cautious. He could not say whether that came from a blow or simply from the body breaking down in the water. He found no fractures, no lacerations, no deep tissue injuries, and the body was badly decomposed, which limited what the surface could tell him at all. So on its own, that discoloration proves nothing. Keep that word, nothing, because it comes back before we're done. But the real autopsy story isn't what Dr. Mitchell found. It's what he was never allowed to examine in the first place.
He had some limitations that were not of his own makings that hindered him in coming to some final conclusions at this point. He was missing the neck structures. Parts of Nolan Wells' throat and neck interior were absent from the body because they were retained by the state investigators for further evaluation. Without those neck structures, Dr. Mitchell could not rule out whether a neck injury was a contributing cause of death. So that's very important. We already know that he possibly could have had some blunt force trauma to the back of the head, but he could not determine if the man may have been strangled or anything because he didn't get the neck structures. The state of Mississippi decided to keep the neck structures. Why didn't they just take a specimen, a sampling of the neck, and send some of the neck structures to Dr. Mitchell to examine? Or why not invite him to Mississippi to examine the neck structures? But they're mysteriously missing. And so that's a very key piece of evidence. It seems that all of the key pieces of evidence Mississippi kept back. They state had already dissected the internal organs. They did not send, I don't believe, the lungs Dr. Mitchell stated he could not observe the lungs for water intake to verify drowning. So that's very important. He also could not analyze the stomach contents. I was listening to a coroner out of Richland County in South Carolina. She was saying that normally the stomach contents are put into a container so that they can be analyzed. Dr. Mitchell should have had access to these stomach contents to see what the stomach contents were. I mean, he could analyze them, and certain things would tell him whether or not this man died from a drowning. And he also did not have access to any original toxicology results from the state. So he was hampered in his findings. But it's very, very, very concerning about that red discoloration. And then what's the reasoning that the neck structures were held back?
The neck structures, parts of Nolan's throat and neck, were not in the body Mitchell received. The state kept them, and without the neck, he could not rule out a neck injury. He could not rule out strangulation. Think about that in plain terms. The one region of the body that would tell you whether a person had been choked was the exact region the independent doctor never got to see. And it doesn't end there. By Moore's account, the lungs weren't provided either, so Mitchell couldn't check them for water, which is how you actually confirm a drowning. The stomach contents weren't available to analyze. The original toxicology wasn't shared. Now, I want to be fair here, because fairness is the entire job. Retaining tissue for further testing is a real thing that medical examiners do, and there can be legitimate reasons for it. But that isn't the question Moore is raising. His question is why the state couldn't send a sample or invite the family's pathologist to examine the neck in Mississippi. Why the one piece that could answer the biggest question of all is the piece that went missing from the second opinion. That's a fair question, and as of tonight, it has no public answer. Then there's a different kind of evidence entirely, one that isn't a thing at all. It's an absence.
A lot of questions. I heard Attorney Crump to say that he's trying to find answers for the family, but he's left with more questions than answers at this time. And a lot of this is in the purview of Mississippi, the state of Mississippi. They had the body first. They got to the body first. They saw the body positioning when it was first found. So we want the Jackson County coroner, Bruce Lynn, to be very transparent and do his job. We want the chief state medical examiner, Stacey Turner, Dr. Stacey Turner. She's also a forensic pathologist, to do her job. They have been very concerning. Their actions have been very concerning to date. To me, Dr. Stacey Turner, for one, I think the past 5 black young people that have been found dead under suspicious circumstances, she has not once ruled that any of that was a result of foul play. It's always some asinine reason that pales belief. She thinks people are committing suicide when their legs are broken. It's just not going to happen.
Hundreds of people on that island for the 4th of July. By some accounts, 300 or 400 bodies scattered up and down that beach. And not one of them, not a single one, has come forward to say they watched Nolan go into the water. Nobody saw him swim out. Nobody saw him dive. Nobody saw him struggle. Nobody saw him go under. Moore's logic here is simple, and it lands. If this were an ordinary drowning, a strong swimmer caught in a current on a packed holiday beach, that is the easiest thing on earth to report. You would not need a lawyer to say it. You would just say it. And weeks later, in a case this loud, with this many eyes on it, still nobody has. That silence is its own kind of evidence, not proof of anything, but a hole exactly where an ordinary explanation should be. And notice what it does to the drowning theory specifically. A drowning on a crowded beach usually leaves a trail, someone who saw the swimmer go out too far, someone who heard a shout, someone who tried to reach him. That trail is how these cases normally get explained within hours. Here, weeks in, that trail simply doesn't exist. No account of a swim, no account of a struggle, nothing. Moore's point isn't that the silence proves a crime. It's that the innocent version of events should have been the easiest one in the world to confirm, and it's the one nobody can. From there, Moore widens the lens, from the body to the whole system around it.
This young man has still, no one till today has stated that they saw Nolan Wells take a dive, take a swim, and have any sign of distress. And so Dr. Mitchell even said the investigation would need to reveal how Nolan Wells got into the water. Was it voluntarily? Was it involuntarily? Was it by force, or was it voluntarily? But no one has ever come forth and said that he took a swim or a dive and had some distress. And so that's very concerning. The lack of that eyewitness testimony. You had 200, 300, 400 people out on that island for the 4th of July, and not one person has come forth to say that they saw him go under. If he had went under voluntarily, taking a swim or a dive, someone surely should have been able to see that and report that easily without a lawyer. They could have saved their hard-earned money if it was just a dive, a swim, and he got in a current or something that it took him under. That is easy enough to report, but that has not happened, and we are way past 2 weeks now since he was confirmed dead.
He isn't just pointing at the sheriff anymore. He's asking the state's investigative bureau to step in. He's asking the Mississippi Attorney General's Public Integrity Unit to examine whether any official mishandled this. He's asking the Justice Department's Civil Rights Division to weigh the racial questions hanging over the case, and he wants the federal prosecutor for the district to open a file of his own. And I have to flag something here, carefully, in both directions. Moore also raises pointed accusations about specific officials, the medical examiner's history of rulings, the district attorney's past record. Those are his characterizations, his read of a pattern. I am not going to repeat them as established fact, because they are one attorney's argument for why he doesn't trust the people running this. What's actually checkable is the ask itself. Bring in more agencies. Let the daylight in. And scrutiny is a hard thing to argue against. So we come back to where we started, the warrant. And the reason it isn't just talk is that Moore actually lays out what sits underneath it. He frames it as circumstantial, and he's honest about that word. He isn't claiming a confession. He isn't claiming a weapon or an eyewitness. He's saying that when you line the pieces up, the most likely explanation, in his judgment, tips toward murder rather than accident. And here are the pieces. The phone that should have been in Nolan's hand, found instead at someone's home, not turned in, not reported, and, allegedly, cleared of its messages and photos. The car keys the family had to physically go and ask for, with a delay attached. The friends who, by Moore's account, went and had breakfast and carried on with the day instead of searching. And the ones who, he says, didn't come to the funeral of someone they'd known since childhood. I want to hold the line hard on every one of those. The deletions are, in Moore's own framing, alleged, and Moore himself insisted on the other side of it, that some of the young men being torn apart online were at that funeral, that he stood with them, took a photo with them, watched them break down and weep. He named that out loud. And it matters, because it's the part that doesn't fit a villain edit, and cutting it would make me exactly the kind of source this channel exists not to be. Add Katie's account. The conflict between her version and the boy's version. The Coast Guard call that had to be corrected. A report that came in that night, but didn't carry enough to launch a search. On their own, Moore says, none of these proves a crime. Together, he says, they clear his bar to sign. That's the distinction the entire thing rests on. Any single thread, pulled loose on its own, has an explanation. It's the braid a former judge is looking at. And this still isn't the end of it. New audio surfaced this week, a distress call one of the friends placed to a private towing company that same afternoon, and it's already reshaping the timeline everyone thought they understood. The district attorney finally spoke publicly too, though not about what happened to Nolan, about why she still won't say more. So here's where it actually stands. The independent autopsy is inconclusive. Foul play has not been ruled out, and it has not been proven. No one has been arrested. No one has been charged. What we have is a former judge, on the record, saying that based on circumstantial evidence, he believes it is more likely than not that this was murder, and that he would sign the warrant to test that in a courtroom. That's his judgment. It carries weight because of who he is. It is still not a verdict. Nolan Wells was 18 years old, a kid his friends describe as the one who was always looking out for everyone else. His family didn't trust the first answer they were handed, so they went and got their own. And the second answer was that there may be no honest answer yet at all. They are still waiting on one. So is he. When there is an arrest, a real one, sourced and confirmed, you will hear it here first, not a moment before. Subscribe so you're here when it comes. I'll talk to you soon.